Alternative Digitalk. Real issues, real talk.
Fellow citizens, following the sequence of events, Uganda seems to be at political crossroads.
I'm not a servant of anybody.
Madam, I know the law.
As such, Alternative Digital brings you the Interface Show with retired Colonel Dr. Kiza Besuje.
Let's keep on the same page on Alternative Digitalk,
As he gives you the alternatives on the transition question, rule of law, human rights and freedom, youth inclusion in governance, economic stagnation, as he confirms.
I'll be always here, Saturday from 10 a.m. in the morning. Be there.
Don't miss the live discussion on the Alternative Uganda, Digitalk TV Facebook pages, and the Alternative Uganda YouTube channel.
The Alternative Digitalk. Real issues, real talk.
Good morning, our viewers. You're most welcome for this show. This is the 13th day of December 2022, and we are coming close to the end of the year. As the festive seasons are also coming in, we want to ensure and always inform you to always be safe, especially in this period of the festive seasons. People want to bring all this excitement, I should call it, and they want to be happy as if life is ending and that is the end of the story. And as you enjoy life, yes, it is necessary sometimes enjoy, but life continues even after the festive season. So that's why we encourage you to be safe and make sure that in whatever you do, at least there is some kind of humanity to the rest of the people, and you extend the love to the people that are following you on a daily basis. I am Kakuru Tumusiime, hosting this show, Tekachi. and before we come to the start of the show, I want to first give you the legal insights, the legal alerts that have happened in the last weeks. And one of the famous ones is a constitutional petition number 15 that was filed by one Dr. Businje Kabumba and Andrew Karamaji versus the Attorney General. In that case, they were challenging the appointment of the 16 judges of the High Court in their acting capacities, and court has agreed and said that such kind of an appointment is unconstitutional, and that's a plus in the legal field, especially in the areas of judges in their acting capacities. Then another one is about the agreements that include it's commonly known as the charpentry, or the contracts done by lawyers with their clients. It normally happens in matters that concern land, and then the lawyer comes to you, makes an agreement that they will represent you in a famous or a certain matter or a certain legal issue, and at the end of it all, if they win a piece of land or if they win such a case against your opponent, then they will take a share of your land. That's about if it's about 5 acres of land, then they say after winning we shall take a share of about 2. So that has also been challenged in the court, and that's not the discussion of today. But today we shall be assessing the criminal justice systems and how it operates in Uganda, how it is taken, how it is dealt with, and what you need to know about the criminal justice systems and how they operate in the different areas. And today I will be hosting Kakuru Tumusiime, who is this opportunity to say hello, and we can start our discussion today. You are most welcome to this show.
Yeah, thank you so much. I'm glad that to be hosted at the Alternative Digitalk show this morning. And our dear viewers, I guess we shall enjoy this morning show and we shall get the basics of the law and how we can go around with it in the current situation. You know, in Uganda, most people just know the law when they are in police and they end there. So we shall try to dissect and try to analyze these issues, educate the people out there on the basics of the law, what they should know before they go into police and the rest. Yeah,
You're
thank you.
most welcome, Kakuru.
Thank you so much.
I think we can give it a start from right there.
Yes.
And my first question would be, and we shall use a lot of examples so that our viewers out there can understand clearly what we are trying to mean.
Yes.
I have, actually I should say I have a complaint against somebody, and I report my matter to police or to the LOC. Actually, let us start from the LOC. What should I expect? What happens thereafter?
Yeah, wait, thank you so much once again. When you have a complaint, let's say you have a dispute between you and your colleague, maybe your neighbor,
Yes.
you go to the LOC, you report. So after reporting at the LOC, there are matters that the LOCs handle and there are matters that are beyond their jurisdiction and their capacities. So for that case, if it is simple and matter, for example, it can be between you and your wife that you had the issues at night, so you need to, you can come in to explain that and sort you. But if it goes beyond that, then he refers you to the police.
Yes.
He refers your complaint to police and he explains to you why they cannot handle it. So when you reach police, you raise your complaint. If it is a criminal matter, it is recorded in the CRB, that is a criminal record book, and they give you a number or a reference. That reference helps you to keep track of your matter. For example, it might take 2 or 3 weeks. So when you come back to police to find out how your matter is proceeding, they will ask you your reference number. So you show them that small sheet. It's normally small. I don't know why they make it that small. Then you start. You give them the number, they track your record. So that is up to police. I don't know whether we can proceed to.
I want you to help us in breaking up which kind of offenses can I report to police, to report it to police. Say they talked about a reference from to police. Is it then later a word of mouth?
Thank you. Maybe if we are to start from the tip of it to explain to that person. For example, there's my colleague who sent me a message. He's in Mbarara and watching us, but he doesn't know how to do this. Maybe I will break it from the start to make someone understand how it comes up. So there are criminal cases and civil cases. So the civil cases are the disputes between individuals. For example, it's Kato against Kakuru. You have your issues, either land or what. You discuss that, then you go to court. So for civil cases, you go to court direct. And then there are criminal cases. Criminal cases, these are cases against the state. In their nature, they are against the person, either their right, either the right to life or what. There are many cases. And in the Uganda system, these offenses are stipulated in the Penal Code Act. So this Penal Code Act is the one that explains all the offenses, the ingredients, and the punishments. You know, in Uganda, the constitution is, it is the basis of all the other laws. So, I would use some articles. Article 2, for example, it says that the constitution is the supreme law of the land. So it means any other law that is inconsistent or in contradiction with the constitution is null and void. So, and then they continue under Article 28 to say that for a person to be charged, that we call it a principle of legality. For a person to be charged with an offense, it must be clearly written down and its punishment well stipulated. I may give an example. For example, there are some cases we the local people, we the normal people look at and you say like this one has committed this offense, when actually it is not anywhere in the penal code. So that one cannot stand. So if for police to start its arresting and the rest, it will have to look at the offense. For example, if you have a complaint, there is theft, there is murder, there is rape, there is, name it, those offenses, you go to report. So if police finds this offense is well stipulated, then they will receive it and give you that reference for it to start.
Okay, so now I am at police and they have received my complaint and given me a reference number.
Yes.
What do I do with that reference number and what does the police do after?
Yes, well, the reference number, as I said earlier, it helps you to track your report. For example, at police, after for several times you go there to find out, you may find different police officers. So if you report that offense, the police will give your file to this IO.
Yes.
It is the officer in charge, right? The investigating officer. So the investigating officer will hold your file and look through it, sees your complaint, then he goes on to do an investigation. That is if you are not arrested. Then there are offenses where they arrest you immediately. For example, they have found you stealing, and then the police is moving around. They arrest you, they take you without a complaint. So if you complain, then they arrest a person, and in arrest, it is a process of arrest. Okay. For example, there are two ways of arresting. There is an arrest with a warrant and an arrest without a warrant. For example, as I said earlier, the police patrol may be moving on this road, maybe going its own way. And then as they are proceeding, they find maybe a mob trying to kill someone.
Okay.
They don't have an arrest warrant, but they will just arrest the people they find. That is one. Then the second one is where they have an arrest warrant. An arrest warrant is a document by court to arrest someone in order for them to appear to answer some charges. So if it is given, then the arresting officer will come, identify him or herself, and he will arrest you. So at that point, there are ways of how they can arrest the real
so now
arrest.
Take us into those
Yes,
ways
so the first one,
do the arrest.
the first one is submission. For example, if an officer comes, identifies him or herself, I'm officer this, and I've come to arrest you with the arrest warrant, you can submit yourself willingly. You say, okay, let's go. That is one. Then the second one is by touching. For example, he finds you, I'm this and this, I'm arresting. If you try to hesitate, he touches your arm or whatever. Then the third one is, for example, you are here and they have arrested one person and then the rest are still on a run. It means if this police officer has already arrested one of the culprits and on his way he finds another, he can arrest. It is also by touching, by confinement, by submission. Confinement meaning taking you into the police custody itself.
Okay.
Yeah, so that is with the arrest.
Now I reported my offense or my complaint to police. They gave me the reference number and they have now done the arresting part.
Yes.
Now the person I reported to police is taken in the custody, the police custody.
Yes.
Is my role as a complainant, where does it stop? What do I do after as a complainant in this?
Well, thank you for that question. Actually, I've found many instances where the complainants actually want to take over the matters and leave alone the police. But no, that's not the way it is. If you report and the person is arrested, The police will hand over the file to the investigating officer.
Yes.
This is the officer in charge of your matter, going to find the evidence and the rest. So where the file is handed to an investigating officer, the investigating officer will actually come and do the investigation, take on evidence and the rest.
Yes.
So as he taking on, he will be coming back, checking on how far. So if he gets enough evidence, he will draft a charge sheet. So a charge sheet explains the offenses you're charged with and the particulars of those offenses. So he sends the same to the DPP, that is the Director of Public Prosecution.
So before we go to the sending of the same,
Okay.
are there instances where the evidence gathered by the investigation officer is not sufficient enough?
Yes. For example, as we go into the criminal system, there are ingredients that must be proved for one to be committed, to be charged with an offense, and then if the ingredients are proved, the person is convicted. Okay. So the investigating officer goes on and makes his investigations, gathers evidence. So he sends the same to the DPP for advice.
Okay.
The reason why they send it to the DPP, the DPP is provided by the Constitution. This is a person who takes over criminal cases on behalf of government. So he has the mandate to advise police on what to do. Because the purpose of arresting and doing the investigation is to make someone committed, charged, and if the ingredients are proved, they convict you. So the DPP advises police. For example, you have got someone stealing, but you have not got what he stole, you have not got the rest. When you forward that report to the DPP, he would advise that no, we need further investigations on this. For example, if it's a murder by a panga, they will tell you no, go and look for that panga, go and look for the crossings, go and look for the blood stains, the pieces of evidence to help you prosecute. Yeah.
So, where the evidence is not sufficient to sustain a charge, what happens to this person who is arrested?
Where the evidence is not sustainable and not enough, they can withdraw the case. And in this process, the DPP will advise police that we have no evidence to implicate this person, so we can withdraw this matter.
Okay. Yeah. There are instances now before we can proceed to court.
Yes.
The Constitution provides for the 48-hour rule.
Yeah, true.
For the person to be taken to court and charged.
Yes.
And then they can be charged and the same can happen. But now, in the instances where the investigation does not take place in the 48 hours, and this person is still in custody as somebody who is actually reported, I reported you,
Yes.
he's an accused and he's in custody, 48 hours have ended and they have not charged this person.
Yeah, well,
what happens in such circumstances?
Yeah, thanks for that question. We've got clients who come to us saying, my person has been in custody, now it's 4 days, but there's nothing done, he's not in court, he's not where. Well, the 48-hour rule is a basic, I may say, and I'm trying to simplify it for every person there out to understand. Because there are cases which need further investigations and the rest. For example, I will tell you some matters which can happen within the 48 hours, then you can be taken to court. For example, where the evidence is there, ready. Okay. The other instances where where the DPP actually says no. You see, with police, they try to bring in now their real personalities, and they want to make money from these people because they don't know these laws. So when they arrest you, they keep you around hanging because they want to extort money from you. Not to take you to court, but to get money. So some of these are the practices done by police. But some of these offenses, for example, most of these capital offenses, it is not mandate. That is an exception to the 48-hour rule. For example, murder, rape, terrorism, and the rest. Where they get that, it needs further investigation, it needs gathering evidence, it needs the rest. So if it falls within that, then you can not claim under the 48-hour
48
rule.
hours.
Yes.
Okay.
And it is not mandatory that every suspect can be taken to court within the 48 hours.
So while at police, and this accused person is in custody, do these accused people also have their rights that they have to enjoy
Yes,
while
yes,
at police?
yes.
And what are some of the rights that they're
yeah.
entitled to?
Thanks for those questions. I'm liking this show because it is trying to enlighten the citizenry out there. Because one, before I go to the rights, the first right everyone has is the right, for example, under Article 4 of the Constitution. This Constitution should be interpreted in all languages for every person to understand. But it is only in English. So it means someone who didn't go to school cannot know anything about this. And these rights I will highlight some of them, but all of them are in the Constitution. Okay. So some of them, for example, at the time of arrest, you have a right. An arresting officer will explain why he's arresting you. He will tell you the rights. For example, some of the rights are the right to stay silent, the right to maybe the next of kin, you may be here now, for example, at work, then they arrest you. I'm not saying they will arrest you, but I'm using it as an example. When you're arrested, no one knows about it. So when you reach, you have a right to inform the next of kin. You have a right to access your lawyers. For example, some of these rights, as I told you, these people don't know. But the lawyers will help them to understand their rights. And then while in custody, there is a right to personal liberty. But then an exception of that one is when you are arrested. Because if you are suspected of an offense, the police officer will take away your liberty by arresting you. Okay. Yeah, but in arrest, then you have the right to, inhuman and degrading that one you have to be protected from that. For example, the torture. There are some cases I read about them where the suspects are being tortured before they are brought to court. But when you bring a suspect to court while he's injured and the rest, it might not suffice for you to prosecute that matter because there will be now rights of the human being tortured and victimized and the rest. Then the other right is the right to access medical attention. Okay. But this cannot be, while at police, this is not the responsibility of the government. No, it will be at your own cost. Okay. Yeah, then you can, the rest, I think those are most of the rights these people enjoy while at police. Of course, the right to stay silent, these words, most of these suspects, when they reach at police because they fear being inside the custody, they start talking anything because they think they will be released. No, that's not. Because the words you say can be used against you while in court. So the police must inform you of your right to keep silent.
So while at police, and how many days must you have stayed at police in their custody for you to be accepted to get bond?
Well, bond has no hours of limit, no. Okay. At any time, for example, they can arrest you at 10, then by midday, you process your bond.
And what are
or they can arrest you, you even spend 3 days without a bond.
So what are some of the considerations for you to be given police bond?
Well,
at what cost is it actually given to you?
Yes, thank you so much. We've got people who come to us and say, I was at police, but then the policeman asked me for 200 to release me. Remember, a release on a bond does not take away your liability. No. They're just giving you, I may call it, break, what can I use? But they are just releasing you, awaiting for the investigations, and you'll be taken to court. But bail is free. That is under the Police Act, Section 38. Bail is free. It should not pay any coin. But the practice, however, is different from what the law states. Of late, I've not seen people moving out of police without paying a penny, but that one is done out of their conscience, but it is nowhere found in the law.
Okay, thank you so much for enlightening us about that. But now, we have handled the issue where the evidence is not sufficient to sustain a charge against this suspect. And then now we should move further to the instances where, by the advice of the DPP, he or she states that the evidence that is gathered on the same matter is sufficient to sustain a charge against the accused person. What follows thereafter?
Yeah, when this file is forwarded to the DPP, and the DPP actually finds evidence sufficient to sustain the charges, they will forward the same to court. Of course, the DPP is the one who prosecutes. So he files the charge sheet to court, and then it is recorded and then given the hearing dates and the rest.
Okay.
And for example, if you are given bond at police and then your file is taken to court,
Okay.
you'll be informed that your matter has been called, you are appearing on this date and this for either mention or what, depending on the
stage.
Yeah, on the stage of that. So after that, you are given the summons to appear. That is if you are on bond. But if you are still in police custody, they will just take you to court. And reaching court, you just enter the dock as a normal process. Then when they read your charge, they will read the statement and the particulars. Then they will ask you to take.
So what is normally included in those particulars you're talking about?
Well, the statement of offense will. Let me talk about the charge as a whole. For example, a statement of offense will talk about the offense you are charged with. For example, murder, contrary to section 189 and the rest. You get? That one will be the statement.
Statement.
Yeah, so it will talk about the offense you have committed and then the section of the law. Because I told you about the principle of legality, that any person to be charged, the law must be clearly stipulated and its punishment. The offense and its punishment must be clearly stipulated under the law. So that is the statement. Then the particulars of the offense are the details of how you committed that offense. For example, I will use just a scenario. For example, Katu, aged 30, resident of, I don't know, this is Konge, the Mnyakore by tribe, farmer or teacher, I don't know whether. Then that on this date, for example, this is the 12th? 13th. That on the 13th date, Katu with others, if you had others, at large at this place, for example, in Konge, using what guns, robbed something. I'm using just an example. So they will particularize all the contents of your offense and trying to bring out the ingredients, as I told you. So that is it for the charge. Then it is signed down by the preferring officer, and yeah.
Okay. So that is at that stage. Now, there is somebody who has sent a question here, and before we can proceed, I think it is important that we answer.
Okay.
They are asking, please ask counsel, under what circumstances can I hold an arresting officer personally liable for an unlawful arrest, an unlawful detention, and the circumstances where I can sue the Attorney General or both over the same as mentioned above?
I don't know what his intention is, first of all.
This is a question I think he wants to
know
hold accountable people who arrest.
This is where he can hold accountable the arresting officer. For what? I don't know what's
for an unlawful arrest. Personally, the question goes, under what circumstances can I hold an arresting officer personally liable for an unlawful arrest? That's one. An unlawful detention, and the circumstances where I can sue the Attorney General or both, meaning the arresting officer and the Attorney General over the same as mentioned for unlawful arrest and unlawful detention.
Yeah, thank you for that question. Arrest. The police officer, the arresting officer, has a right to arrest you. And at that stage, you can't say that, he unlawfully arrested you. As I told you in the start, he can arrest with or without a warrant. For example, he's from his police station and coming here to buy something, then he finds you committing a crime. He arrests you. He takes you to detention. So there you can't determine whether it is unlawful or lawful. As I told you, he has to explain to you the rights you have as a suspect at that point when you are going to the police. So when you reach police, they will, of course, give your file to the investigating officer to go and investigate. At that point, you cannot hold the officer accountable for unlawful arrest because they.
But now, in these circumstances, where the investigative officer has gone on with the investigations, and they find that there is no evidence against me, but I was arrested and detained for even how many days?
True.
Who is accountable for that?
For that will come after they have withdrawn the charges.
They have discharged me.
Yeah, they will. If they find no evidence against you, they withdraw the charge. So after withdrawing the charge,
so what
now
remedy,
that's when you come in for your unlawful detention.
What remedy do I have for having been arrested and detained for no offense?
Now you can sue for the unlawful detention.
So this is now where the question is.
But that is after.
Now when do I sue the person who arrested me and detained me, and when do I sue the other?
Well, there's what we call vicarious liability. And there's, for example, in that instance, you know, the Attorney General, he's talking about the Attorney General. He's the one who represents government. Okay. And police falls under the government. Okay. So you can sue Attorney General. That means if you succeed with your petition, you get compensated by government because of its officers. The other one is you can sue the police officer who arrested you. But normally, people don't go for the police officers because of their capacity and status. Someone will want like 200 million, then the police officer is getting small salaries, so it is rare for them to get the intended damages. So that's where they normally go for the Attorney General because government has money.
So now the choice is yours to.
Yes, you can both sue. You can sue both of them, or you sue one.
Okay, now I want to first take you through these questions because I see there are many and very flawed. This one also says, but this so-called right to keep silent really confuses me. What if I choose to talk and talk and talk? Can what I have talked immediately after my arrest be compel my arresting officer to have more charges than the first ones that led to my arrest?
Yes.
So it means in whatever you say.
You have a right to keep silent, but you also have a right to talk. Okay. But what you talk can be used against you. You know, in law there is what we call admission. Okay. For example, the police officer has come to arrest you, is asking you, where are the cows you stole, or where is the money you stole from bank last night? You say, I kept some at my office and then the rest I gave to Kato. You have admitted. So you are no longer rejecting, you didn't steal.
The words you say can be used against you.
So if this police officer reaches and uses those words against you to implicate you actually, you cannot go against them because they are from your own mouth and you are not forced. But for those to be considered, there are circumstances, there are instances they consider that, for example, they consider whether the arresting officer did not force you, or there was no torture, or or duress. Because if someone induces you to speak something, for example, there's a matter we're handling, this police officer told the accused person now that if you talk the truth, we shall leave you to go. So the guy talked about everything, and then they asked him, okay, tell us about the other people you had while committing that crime. And then for you, we shall leave you out. So the guy talked everyone. So after they told him, okay, remove your shoes and get in. He was like, but you told me. And he couldn't change the things, no.
So can such statements be used against the person?
Exactly, yeah. Exactly. Where they can fail is when this accused person claims they were got maybe by duress or by torture or by, but otherwise they can be used to implicate that person.
Okay, so this other question from Mwonge Feroz. Can a citizen arrest law enforcers breaking the law? For example, court bailiffs implementing court orders at night. That is from Mwonge.
Well, a citizen arresting, well, any person can.
Law enforcers.
I would say no. Because by the time he's talking about the bailiffs.
The bailiffs.
By the time these
implementing court orders at night.
Well, at night that is unlawful, but then they have the order.
So when do the citizens have the right to also enforce the laws that are set out under different?
For example, if Kato, you are moving around and you find someone committing a crime, you can arrest them.
And in this case, we are talking about law enforcers. Like
but
bailiffs.
you see, at that point, you see, with these bailiffs and eviction, this is a risky business. You as a normal citizen, you might go there trying to arrest because you see they are doing the wrong acts. They end up killing you because they are already authorized to do what?
But in this case, if I also have the manpower to also
that
act
is
upon
true.
them.
If you can
Can I? Because this is the question. I think he is interested in knowing whether he has the right to arrest law enforcers breaking the law.
Yeah, true. If he has the capacity and he doesn't risk his life being taken away, he can arrest.
So
he has that right.
He has the right.
But then he has to be conscious on how effect the arrest.
Okay, I see this, Joseph Okanya. I love your discussion. Thank you so much, Joseph. I think this is a little bit personal, but I will not read it. Okay. Are these two moderator and the Vista twin brothers? They look alike, but that's one. This one, Feroz asks again, and that everybody is entitled to legal counsel once arrested. But who pays for those who don't have lawyers or cannot pay legal fees?
You can repeat that?
Everybody is entitled to legal counsel once arrested.
True.
But who pays for those who don't have lawyers or cannot pay the legal fees?
Cannot pay the legal fees. Thanks for that question. Yes, you are entitled to legal representation, true. And that representation is at your own cost. Okay. So it means if you cannot afford a lawyer, then you will not hire one. But then the exception is for the capital offenses.
Okay. So, but you should simplify such words, capital offenses.
Sorry. Okay.
To the viewers,
so about that, these are offenses that take a punishment of either life sentence or death.
Okay, those are capital.
Capital. I may break them, maybe defilement, rape, murder, terrorism, treason. They are capital in nature.
Okay.
Those ones, you are entitled to legal representation. But if you cannot afford as an accused person, then the government will hire you a lawyer to represent you. Because in the nature of those offenses, they need a lot of ingredients to be proved. And you know how risky it is for someone to suffer death because he didn't have a lawyer. There are some terminologies we use in court which this person, the accused, might not understand, yet they are simple, and they end him being convicted. So because the government risks, taking these people when they are innocent and arresting and convicting them, they provide legal representation if someone does not allow.
And the government is responsible for meeting
to pay them. Yes.
So does this mean that even when I have the legal knowledge, do I have any right to represent myself in any matter?
Even if you are an advocate, you can represent yourself. Even if you don't have
Is it limited to lawyers or to everybody?
No, every person. As long as you can stand for yourself and proceed with the court processes. But what you should remember is this will not save you on the legalities of the law. No.
Okay.
For example, if you are representing yourself, and the person you are against is represented by a lawyer. He talks terminologies, the legal terminologies you don't understand, you will not ask court for interpretation, no. Or else if he quotes cases you don't know, you will not say, my lord, I'm not aware of this.
I'm not a lawyer, so I don't understand.
That's why I don't understand, no. Yeah.
Okay, I think we should take this question as well, and this one asks, what's the difference between police bond and bail?
Yeah, of course. Thank you for that question. Yeah, by the way, many people confuse the two, bond and bail. But for police, bond is given at police. It's even police. It is a police form, yeah.
Okay.
It is police form 18, yeah. Police bond. So it is given at police. When they arrest you, before you're taken to court, you'll be at the police custody. So at that point, you can be given police bond. And then for bail, this is when you go to court.
Okay.
For example, you have been charged before a magistrate and you appear in court. So that is when you can apply for bail. So bail is for court and bond is for police.
Is it
That
the
is
only
the
difference? Or
that is the simplicity of it. And the other one is bond is free.
okay.
But for bail it can be cash or non-cash.
Okay.
Non-cash, it doesn't mean they forgive you. But they will say, we have given you a non-cash bail of 500,000. And your sureties maybe 200 each, non-cash.
Okay.
It does not mean you have gone free, no. In case you default on car appearing as the court deems you to, and there they can come to you, arrest you, you pay that money.
Okay.
Because the reason for this money is, for example, in the simplest terms for everyone to understand, you know you are in police by then or prison, and now you are going to be released on bail. But then it does not mean your matter has ended, no. So they will arrest the money. You go out to prepare. It means after your matter has been adjudicated and maybe you are convicted or you're set free, you can claim for your money.
Okay.
Yeah. And for bond, it is free.
Yeah, questions are just coming in and we should not leave them unanswered. Feroz asks again, is there a maximum number of cases a lawyer is supposed to handle in a year, just like it applies to judges?
The maximum? No. It depends on your capacity.
So it's a matter of
On how you can prepare yourself.
how many you can handle as a person.
Yes.
Okay.
If you can manage, you can find every year from Jan to December, you have a court matter.
Okay. Joseph still asks, well, what a great picture you are bringing to our knowledge. I am truly learning a lot. My question, is it also a right for one who accused to settle matters out of police and the case is closed if we both parties are contented, still at court? Can we settle matters out of court, out of police, like we do settle matters out of court?
Well,
In simple terms.
no.
If we are all contented and we be like,
it will depend on which matter.
okay,
But if it is a criminal offense, as I told you, the offense is against the state, no.
but for civil
If it
matters,
is a civil matter, for example, you have a land dispute, you're disputing where you pass
The boundaries.
your boundaries, and you reach police, no, you can't say no. Let's talk as people.
okay,
But for criminal, no. And by the way, in the villages there, most people do it. For example, these defilement cases and rape. You
but
find-
those are criminal in nature.
Yes, but they practice outside by many people. You see, these parents, some of them don't have money. And when they hear someone raped their daughter, they just call the LOC. And because they know, Kato, you have money and you committed that, they will say, no, give us 20, we leave. But that is illegal. Because if police knows about it, it will come again and arrest you. Yeah. So those ones are done, but they are not legally founded.
Right, so I think that question is answered. At police, it depends on where your matter falls. If it's civil in nature, then it can be resolved at police.
Yeah.
If it's criminal in nature, then there is no way you can go away with it. Thank you so much for your questions and for watching us. we had reached a point where this person is brought to court.
Yes.
The file is sanctioned and he's appearing in the dock.
Sure.
What happens at that stage so that the people can know?
Yeah.
Because like somebody asked, at that period, most of the people don't have the financial muscle or the money to hire out lawyers, and they don't know what they should do at that stage. So you can help them understand, and maybe next time they are taken to court, they can know where to start from.
Yeah, well, when the file is sanctioned, and now you are in a dock,
Okay.
they have read out your file, so you are in a dock. They first ask you which language you understand.
That is a must.
Yeah, because the official language of court is English,
Okay.
but some people don't know English. So the first question they will ask is, which language do you understand? The reason for this is to help you follow the proceedings and understand whatever is put to you. So if you don't understand English, the court will provide an interpreter.
Okay.
And if you understand English, then and you're well conversant, then you can proceed with the same. So after that, you have spelled out the language you are well conversant with, then they will read your charge.
Okay.
That is, as I told you, that includes the statement of the offense and the particulars of the offense. So when they read it to you, now the judge or magistrate, whoever, will ask you to plead. How do you plead? Or do you know these statements? You know, some people are confused by the questioning of the judges and magistrates. Someone will read the particulars and asks you, do you know these statements? You say yes.
Because you understand the English that they are reading to you.
Yes, you say yes, and now a plea of guilty is entered against you because you have accepted, you know them. Someone might not use the word plead. How do you plead? But some judges or magistrates asks you, how do you plead? You say, guilty or not guilty? So at that point, but before we go to the plea, there are cases, you know, in our judicial system, there's what we call jurisdiction. Like,
Yeah, because
the
I wanted to
boundaries.
take it to that.
Yeah.
There are offenses where a person is brought before a magistrate's court and
Yes.
they say, we don't have the jurisdiction to
Exactly.
try your matter, and therefore you should not say anything, and then you are remanded.
Yeah, we were somewhere some time back, and then as we had a discussion as normal people, someone was bringing in the political issue of the honorables, the Segini and Sewanyana. But these guys are brought court every what, and nothing is going on. Why? No, it is a process. For example, we have magistrate courts and then the High Court. There are jurisdictions under the Magistrates Court Act. This Magistrates Court Act stipulates what offenses are triable by the magistrates. Grade 1 and Chief Magistrate. The Grade 2 magistrates are being phased out, so we consider the Grade 1 and Grade 2. And these offenses, as I told you, under the Penal Code, each offense stipulates the punishment. So the jurisdiction, one is territory. And then the other one is a territorial jurisdiction, and then the powers, the sentences.
Okay.
Yeah, so you can be limited by the sentencing powers. For example, a magistrate cannot sentence someone to death.
Okay.
There are those offenses. So where an accused person appears before a magistrate with, for example, murder, as I told you, those capital offenses triable by the High Court, what the magistrate will simply do, they will read out the charge to you person, but they will tell you, you cannot plead because we lack jurisdiction to try this matter. So at that point, they will keep reading to you the statement and reading to you the charge, but then they cannot allow you to plead. Because at that point, maybe the prosecution is still looking for evidence, or maybe the police is still trying to find and gather the rest. So they will keep you at the magistrate's court. And when everything is finished and prosecution is ready to proceed, they will come and notify the magistrate that investigations are done and we are ready. Then the person might be committed to the High Court.
Okay.
Then that's when you can now start appearing to the High Court and starting to
And
defend
taking
yourself.
the plea.
Exactly.
We should go back to the comments, and Hiona says, keep the good work. We still need a lot to learn about the law, and that is why we brought this show on the Alternative Digitalk. So we are always live on Tuesday, 11, discussing matters that concern the law and order. So always be up to date and follow our shows. Ini Mutoni, thank you for following this show, and thank you for watching. Then Feroz is asking, in what circumstances can someone who is a civilian be charged in a military court-martial?
Well, that's a question, but I guess that person is not asking it on a political matter.
I'm not sure, but
Because
this is a question.
most of these questions brought to us are someone has the political mind, but he wants to mix the same with the law. No, that's not how it works. But for a person, a civilian can be charged in the court-martial.
So under what circumstances?
Circumstances, yeah. That is, for example, if you're found with the military attire, now you are charged under the military law, that is court-martial. Okay. If you're found with a gun, or if you're found engaging in activities, in activities that use maybe those firearms or the rest, as a civilian, can be tried. Or you have military outfit. You know, at some point they were talking about the red berets and the rest being military attires. So if they find you, they can try you in the court-martial even if you're a civilian.
Okay. As we almost come to the conclusion, and in relation to the same matter in the military court-martials, do the civil lawyers also, I should not say call them the civil, but the civilian lawyers, do they have audience in the same court-martials as well?
Yeah.
Or it is only limited to the lawyers who are in the profession?
No, as I told you, the right of an individual is to have a legal representation. And if you as an individual are tried in the court-martial, you can hire your private lawyer. You've seen lawyers going to court-martial for matters.
So it is
not
open.
limited to lawyers, no. Yeah.
Okay. I think we shall say, and we are about to call it to the end of this show. But then before we close up this show, I want you to highlight some of the issues. And we have had people who lack, I should say, or who don't have the capacity to have the legal representation in matter, especially in the magistrate's court, where the application for bail can be oral or written, not specifically written. And some people get stuck in the instances where they have no lawyer and they feel they should be given bail at that position. How should they deal with it? And do they even have audience to apply for bail on their behalf as individuals, not lawyers?
Yes, thank you for that.
And what should they consider as we...
Yes, every person can address court on the same matter. And as you said, for example, under the magistrate's court, the bail application is oral. Yes. Normally it is oral. And if you are an accused person, you don't have a lawyer, you still have a right to bail.
Okay.
Provided you meet the requirements for you to be granted. For example, you have substantial sureties, you have their sureties, then you have one is sureties. If you have substantial, you can raise it in court. You say, Your Honor, Your Worship, I'm here, but I have sureties and I'm praying for bail. As an individual, it doesn't mean you have to be a lawyer.
Okay.
And if you prove those ones, of course, there is illness. There are many grounds for granting bail. Then there's age, if you have advanced age or sickness. So if you prove those grounds and you have sureties, substantial. You know, everyone can be a surety. But substantial ones are those ones who may do all it takes to make sure you appear as and when court needs you.
What happens to these people who don't understand and use English so well in the same circumstances? As you said, court language is English.
Yeah, there are interpreters, as I told you. If you say you're not conversant with English, maybe you know Ruchiga, maybe you know Uganda, they'll bring an interpreter. So as you speak in your local language, the interpreter will also interpret to the judge or magistrate. Yeah. That's
Okay,
how it
as
goes.
we close, there is this final question, I guess, and this says the court-martial things. The court-martial things are more or less jungle laws. For example, how different is illegal possession of firearms, which is tried in court-martial, different from that as tried in civilian courts? Court-martial should be left for army men. Period. I think this was a concern. And we appreciate. And then, Mchivi, thank you for watching as well. And our audience have been so interactive. I guess time is not on our side, but we shall call it the close of today's show. And we shall get so many other shows in relation to the same matters. And I will give him about 2 minutes to give his last and closing remarks for today's discussion.
Yeah, well, thanks. This has been an interactive show, and I'm glad, and I hope to be coming here as and when I'm invited, because we still have a lot to tackle in highlighting the citizenry and their rights. You know, these are basic rights.
Okay.
The rights one should understand from the onset, so that you don't go into issues of, you know, being arrested, you know, doing what. But then the rest is, the other one is, the ignorance of the law is no defense. If they find you, you shouldn't start saying, but I didn't know this was an offense. No. They just charge you, and then, you know, we are equal. There is equality under the Constitution. So we are all equal. Whether you are a minister or you are a farmer, local, deep down in our village there, in Tungamu, you all be treated the same when it comes to civil or criminal matters. And the other one is, our viewers should just take time and try to consult here and there. Get the tips of these rights. They will save you a lot. Because many people spend a lot of money on things they would have done by themselves. But the other one is, they shouldn't ignore consulting lawyers. No. Because lawyers are there for their help. Maybe as I wind up, my friend Ini Mutone was trying to send me messages here, but I think she's in the US. She's my good friend. Thanks for watching. And our fellow colleagues, everyone here, yeah, you should keep joining Tekachi and other Digitalk shows, because they are educative. Yeah, and we learn a lot from them.
Thank you so much, and we cannot add it up anymore, and we shall come almost to the close of the show. But before we come to the close, my colleague here says that I think in relation to the issues of the court-martial, he's saying that imagine a general with no basic legal mind chairing a court. I think that's the setup of the court-martial. We shall not go into the legalities and the nitty-gritties that fall there.
Yeah. Briefly, before you conclude on that point, I think last week there is a matter that came up before a magistrate. So this person, to his understanding, thought the magistrate was doing injustice because he followed what the law stipulates.
Okay.
But what the judges do, or magistrates, is not making law. They just interpret the already made laws. But someone was pinning the magistrate as if biased, as if had told, you know, which is not. For a magistrate, he was just enforcing what is already written. So they shouldn't always criticize judges or magistrates for passing decisions basing on the law. No.
Okay, and as they always say, that justice shall not be delivered on mercy and emotions, but we follow what the law stipulates, and we shall not push it any further. But thank you for being a good audience. Thank you for your reactions and comments, and our page is always open for any comments, and we shall be available to answer for any concerns, any questions, any comments, and we shall be grateful for your feedback. Always follow us, share the shows to different people, and always invite your friends to always follow and watch our shows. We are here to give knowledge that is not that shall not be paid in monetary terms, but your data can help you understand something that you did not know today, and at the end of the day you will know it, and you'll be able to pass it to the rest of the friends. I shall see you next Tuesday as we host a different guest, special and specifically on a different matter. And if you're interested in understanding any matter, you can always inbox the Alternative Digitalk. Follow me on my Facebook and Twitter at Tumusiime Kato, Facebook Tumusiime Kato, and you can send your concerns. If you have any topic you are interested in, you can always send it in, and we shall look into and host somebody who will help us, all of us, to understand a different issue at a time. Thank you so much for being a good audience, and the people I've worked with, thank you so much for making this happen yet another day, and see you next Tuesday, and have a lovely afternoon.
The Alternative Digitalk. Real issues, real talk.